मंशा के रिमार्क्स। पार्लियामेंट ने चीफ जस्टिस का इख्तियार 2 सीनियर जजेस के साथ बांटा, कौन सा बुनियादी हक मुतासिर हो गया? जस्टिस अतहर मिनुल्लाह का सवाल। वफाकी हुकूमत की सुप्रीम कोर्ट प्रोसीजर एंड प्रैक्टिस एक्ट मुस्तरद करने की इस्तदा।
क्या पार्लियामेंट अदालती फैसलों को बेअसर कर सकती है? जजेस के फैसलों पर बनाए गए कानून के खिलाफ पार्लियामान कानून साजी कैसे कर सकती है? जस्टिस मुनीब अख्तर का सवाल। 3 जजेस का बेंच बनाने का इख्तियार देना दुरुस्त तो 17 जजेस का इख्तियार एक जज को देना कैसे दुरुस्त है? जस्टिस जमाल मंदुखैल का इस्तफसार। मामला अदलिया के इंतजामी उमूर में पार्लियामान के कानून साजी के इख्तियार है। जस्टिस एजाजुल हसन की रिमार्क। सुप्रीम कोर्ट प्रोसीजर एंड प्रैक्टिस बिल में सुप्रीम कोर्ट के ही रूल्स की खिलाफ वर्जी हो रही है। पार्लियामेंट, एग्जीक्यूटिव और सुप्रीम कोर्ट के रूल्स अलग अलग हैं। वकील इम्तियाज सिद्दीकी के दलाइल।
मुल्क में पहली बार सुप्रीम कोर्ट की समाअत घर घर देखने की सहूलत। बतौर चीफ जस्टिस काजी फाइज ईसा ने अदालती तारीख में नई मिसाल कायम कर दी। 5 कैमरों की मदद से 15 रुकनी फुल कोर्ट बेंच के सामने प्रैक्टिस एंड प्रोसीजर बिल पर वुकला के दलाइल बराह रास्त दिखाए गए। नए चीफ जस्टिस का बुलेट प्रूफ गाड़ी लेने से भी इनकार। जाती गाड़ी में अदालत पहुंचे, सुप्रीम कोर्ट पहुंचने पर गार्ड ऑफ ऑनर भी न दिया।
चौधरी परवेज इलाही 1 रोजा राहदारी रिमांड पर एंटी करप्शन हुक्काम के हवाले। लाहौर हाईकोर्ट ने परवेज इलाही बाजियाबी केस में अदम पेशी पर IG इस्लामाबाद के नाकाबिले जमानत और सुप्रिंटेंडेंट जेल अटक के काबिले जमानत वारंट गिरफ्तारी जारी कर दिए। परवेज इलाही को बाहिफाजत घर न पहुंचाने पर तौहीन अदालत की दरखास्त में पुलिस अफसरान के जवाबात गैर तसल्ली बख्श करार। DIG इन्वेस्टिगेशन, DIG ऑपरेशन और SP सिक्योरिटी फर्द जुर्म के लिए तलब।
चेयरमैन PTI की अहलिया बुशरा बीबी के फोन टैप करने और ऑडियो लीक्स के खिलाफ दरखास्त की समाप्त। इस्लामाबाद हाईकोर्ट ने वजारत दाखिला और PTA के फोन टैप न करने का तहरीरी जवाब गैर तसल्ली बख्श करार देते हुए मुस्तरद कर दिया। जवाब से लगता है कोई भी टेलीफोनिक गुफ्तगू की रिकॉर्डिंग नहीं कर सकता। अदालत तहम्मुल का मुजाहिरा करते हुए हुकूमत को आखिरी मौका दे रही है, वरना इंटेलिजेंस एजेंसियों को फरीक बनाएंगे। जस्टिस बाबर सत्तार के रिमार्क्स।
ऑफिशियल सीक्रेट एक्ट के खुसूसी अदालत ने चेयरमैन PTI के बेटों से टेलीफोनिक मुलाकात न कराने पर सुप्रिंटेंडेंट अटक जेल से रिपोर्ट तलब कर ली। चेयरमैन PTI के वकील की सुप्रिंटेंडेंट अटक जेल के खिलाफ तौहीन अदालत कार्रवाई की इस्तदा।
निगरान वजीर आजम 5 रोजा दौरे पर कुछ देर में अमरीका पहुंचेंगे। 22 सितंबर को जनरल असम्बली के इजलास से खिताब करेंगे। निगरान वजीर आजम अक़वाम मुत्तहिदा के जनरल असम्बली इजलास में पाकिस्तान की नुमाइंदगी के लिए पुरजोश। माहौलियाती चैलेंजेस पर आलमी रहनुमाओं से बातचीत करूंगा। बैनुल अक़वामी मीडिया और टॉप थिंक टैंक से भी तबादला ख्याल होगा। अनवारुल हक काकड़ का ट्वीट।
अमेरिका ने मुनसिफाना इंतखाबात को पाकिस्तान के बहरान का वाहिद हल करार दे दिया। IMF की तजवीज़ करदा इस्लाहात पर अमल करने पर जोर। अमेरिकी डिप्टी असिस्टेंट सेक्रेटरी एलिजाबेथ हॉर्स ने वाज़ेह कर दिया, किसी मखसूस जमात की नहीं, पाकिस्तानी अवाम की हिमायत करते हैं।
पंजाब के कई सरकारी इदारे लेस्को के नादहिंदा निकले। वासा लाहौर ने 7.5 अरब से जायद बकाया जात अदा नहीं किए। टाउन म्यूनिसिपल अथॉरिटी लेस्को 3 अरब रुपए से जायद नादहिंदा। पंजाब इरिगेशन एंड पावर डिपार्टमेंट ने 59 करोड़ रुपए से जायद का बिल अदा नहीं किया। महकमा रेलवे के जिम्मे 53 करोड़ रुपए। रिंग रोड अथॉरिटी पर 50 करोड़ रुपए से जायद का बिल। लेस्को ने नादहिंदा सरकारी इदारों की फहरिस्त जारी कर दी।
मुल्तान समेत जनूबी पंजाब के बेशतर शहरों में बिजली चोरों और नादहिंदगान के खिलाफ ऑपरेशन। 136 बिजली चोर गिरफ्तार, 1 लाख के जुर्माने आए। मीरपुर, माथेलो और डहरके में बिलों की अदम अदायगी पर दर्जनों ट्रांसफार्मर उतार लिए गए। हेस्को रीजन में 122 ट्रांसफार्मर्स उतार कर 8 करोड़ 70 लाख से ज्यादा जुर्माना आए।
मार्केट में 150 रुपए में दस्तयाब। लाहौर में चीनी की कीमत पर काबू न पाया जा सका। आम मार्केट में 170 रुपए किलो में फरोख्त जारी।
डॉलर के नीचे परवाज आने का सिलसिला जारी। इंटरबैंक मार्केट में डॉलर 1 रुपए 32 पैसे सस्ता होने के बाद 295 रुपए 53 पैसे का हो गया।
पेट्रोल की कीमतें तारीख की बुलंद सतह पर पहुंचने पर पेशावर में सीएनजी स्टेशन दोबारा आबाद हो गए। हर वक्त गाड़ियों की तवील कतारें दिखाई देने लगी। शहरियों का गैस पर गाड़ी चलाने का रुझान बढ़ गया। रश बढ़ने पर पंप्स पर गैस प्रेशर में कमी की शिकायत बढ़ गई।
पेट्रोल का रिकॉर्ड महंगा होने पर बेशतर शहरियों ने मोटरसाइकिलें खड़ी करके साइकिल का इस्तेमाल शुरू कर दिया। मांग में इजाफा होने पर मुनाफाखोरों ने फौरी आस्तीनें चढ़ा ली। लाहौर में साइकिल की कीमतों में 10,000 रुपए तक का इजाफा। दाम बढ़ने पर खरीदार साइकिलों को सिर्फ देखकर ही दिल बहलाने लगे।
निगरान वज़ीर आला बलूचिस्तान ने गटर में गिरकर बच्ची के जामा खोने का नोटिस ले लिया। क्वेटा की इंतजामिया से वाक़े की रिपोर्ट तलब कर ली। बच्ची 40 मिनट तक गटर में पड़ी रही। पेट में पानी भर जाने से मौत वाक़ई हो गई।
कराची के इलाके डिफेंस से मुबैना अगवा 13 साल घरेलू मुलाजमा सरकारी अफसर के घर से बाजियाब। मुखबी का सरकारी अफसर के घर पर मौजूद शयाम नामी शख्स पर ज्यादती का इल्जाम। चाय में नशावर गोलियां मिलाकर सुलाए रखने का दावा।
लाहौर में शौहर ने मुबैना तौर पर बीवी के जिस्म को लोहे के गर्म रॉड से जला दिया। 4 बच्चों की मां के किरदार पर शक करते हुए रस्सी से बांधकर तशद्दुद करता रहा। मुतासरा खातून मौका मिलते ही भागकर अस्पताल पहुंच गई। पुलिस का मुलजिम को गिरफ्तार करने का दावा।
रामीपुर में फातिमा कत्ल केस के मरकजी मुलजिम पीर असद शाह की हवेली पर पुलिस का छापा। दरगाह के सज्जादा नशीन सूरज शाह के भाई शाहजेब को गिरफ्तार कर लिया। मुलाजमा हिना शाह और फयाज शाह की गिरफ्तारी के लिए छापे।
सानेहा बल्दिया फैक्ट्री केस के मुलजिम हम्माद सिद्दीकी के रेड वारंट दोबारा जारी न करने पर अदालत बरहम। हम्माद सिद्दीकी किस मुल्क में है नहीं पता। FIA ने दोबारा इंटरपोल से राब्ता किया या नहीं मालूमात नहीं। सेक्शन अफसर महकमा दाखिला का मौक़िफ़।
वफाकी हुकूमत का निगरान हुकूमत की कारकर्दगी पर इजहार अदम एतमाद। कराची समेत अंदरूनी सन अमन व अमान की बहाली के लिए रेंजर्स की खदमात हासिल करने की हिदायत कर दी। पानी चोरों को भी किसी सूरत ना बख्शा जाए। वफाकी हुकूमत का चीफ सेक्रेटरी को मरासला।
अमेरिका में तारीख साज फैसला। न्यूयॉर्क में जुमे की अजान अब लाउड स्पीकर पर सुनाई देगी। रमजानुल मुबारक में भी मगरिब की अजान देने की इजाजत मिल गई। न्यूयॉर्क के मेयर ने प्रेस कॉन्फ्रेंस के दौरान बाज़ाब्ता इजाजत दी।
बारिश के बाद पेशावर में जल थल एक हो गया। नशेबी इलाकों में पानी जमा, सड़कें तालाब का मंजर पेश करने लगे। लाहौर, नारोवाल, ननकाना साहब और शेखोपुरा में भी बादल बरस पड़े। कराची में आज से बुध तक बारिश की पेशगोई।
It's okay to be scared. I'm scared too.
Houston, back to hell.
और नई हॉलीवुड हॉरर फिल्म द नन 2 का बॉक्स ऑफिस पर राज बरकरार। रवां हफ्ते मजीद $15 मिलियन का बिजनेस कर लिया। मजमूई कमाई $57 मिलियन से जायद हो गई।
सर, आज की बिजनेस न्यूज मैं कवर कर लूं?
सर, इनका हेयर स्टाइल देखा? पार्टीज के लिए सही है। ये क्या बिजनेस न्यूज कवर करेंगी?
अभी आपने मेरा स्टाइल देखा ही कहाँ है। नया सनसिल्क थिक एंड लॉन्ग, इसमें है योगर्ट प्रोटीन और केराटिन का सुपर मिक्स, जिससे बाल दिखे 2 गुना ज्यादा घने और मुमकिन करे हर हेयर स्टाइल। जब बाल हो थे, कोई भी स्टाइल करो पिक।
अस्सलाम वालेकुम, मैं हूं अली मुअज्जम।
मैं हूं आपके साथ मिस बालाकारी। हेडलाइंस आपने मुलाहिजा की। बुलेटिन का आगाज इस अहम खबर के साथ कि सुप्रीम कोर्ट के फुल कोर्ट बेंच में सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों की समाअत कुछ देर बाद होगी। पाकिस्तान में पहली बार अदालती कार्रवाई बराह रास्त नशर की जा रही है। भारत के खिलाफ आलमी अदालत में केस की समाअत के लिए चीफ जस्टिस बैरून मुल्क रवाना होंगे,
जिसके पेश नज़र इम्कान है कि वक्फे के बाद अटॉर्नी जनरल सुप्रीम कोर्ट में विफाक का मौक़िफ़ पेश करेंगे। अब तक की कार्रवाई का अहवाल जानेंगे डॉन न्यूज़ के नुमाइंदे इरफान सदुज़ई से। इरफान, एक वक्फा हुआ अदालती कार्रवाई में, बताइए कि अब तक जो समाअत हुई उसकी कार्रवाई से मुताल्लिक क्या मालूमात देंगे?
प्रैक्टिस एंड प्रोसीजर जो केस है उसकी समाअत जारी थी और उसमें 1 घंटे का वक्फा हुआ और केस जो इसकी समाअत है केस की दोबारा तकरीबन 3:20 पे शुरू होना और ये 3:30 तक भी हो सकती है। इससे कबल जो है वो दलाइल दिए तारिक रहीम ने, इसके अलावा इम्तियाज़ सिद्दीकी ने और जजेस ने भी उनके जो सवालात थे उनको काउंटर किया। ख़ास करके पार्लियामेंट ने ये जो बिल पास किया था जिसके तहत जो 184(3) के तहत जितने भी सो मोटो एक्शंस हैं उसके लिए एक कमेटी मुकर्रर की गई थी जिसके हवाले से तहफ़्फ़ुज़ात थे और सुप्रीम कोर्ट में दरख्वास्तें आई और उसके हवाले से आज लार्जर बेंच बना जिसमें ये कहा गया कि ये सुप्रीम कोर्ट के जो रूल्स हैं, कवानीन हैं, उनमें मुदाखलत की जा रही है अदलिया की जो पार्लियामेंट की जानिब से। तो इस हवाले से तवील दलाइल दिए गए और कहा गया कि सुप्रीम कोर्ट का जो दायरा इख्तियार है उसमें पार्लियामेंट को मुदाखलत नहीं करनी चाहिए चूँकि सुप्रीम कोर्ट एक मुकद्दम इदारा है। पार्लियामेंट को भी कानून साजी करते हुए सुप्रीम कोर्ट का जो दायरा इख्तियार है उसको भी देखना चाहिए। तो इसके ऊपर चीफ जस्टिस और जस्टिस अतर मिनरुल्लाह उन्होंने भी जो दरख्वास्त गुजार हैं उनसे ये सवालात की। उन्हें ये कहा कि पार्लियामेंट जो है वो मुकद्दम इदारा है और इसमें आपको साबित करना होगा कि कैसे जो सुप्रीम कोर्ट है उसके दायरा इख्तियार में मुदाखलत हो रही है। तो ये दलाइल हुए, उसके बाद ब्रेक हुई और तकरीबन 3:30 बजे दोबारा कार्रवाई शुरू हो गई। जी
ठीक है, ये बताइएगा इरफान सदुज़ई कि इम्तियाज़ सिद्दीकी के दलाइल सामने आए थे, उनका क्या कहना था उसमें?
जी, सुप्रीम कोर्ट के रूल्स के हवाले से जस्टिस मुनीब अख्तर ने कहा कि जजेस की जानिब से दिए गए फैसले भी कानूनी होते हैं।
ठीक है, इरफान सदुज़ई आप हमारे साथ मौजूद रहेगा। एक बार फिर अपने नाज़रीन को बराह रास्त ले चलते हैं पर इस वक्त जो है समाअत का दोबारा से आगाज हो गया है।
graciously be raised once I've concluded my submission. I'd be grateful. My Lords, my first submission, Your Ladyship, my first submission is on maintainability of these petitions.
The Speaker,
My Lord.
the red light is not on.
It is, but it's just, I've just pulled it closer. In paragraph number 6, page 3 of volume 1 of my submissions, page 3, paragraph number 6.
Page 3, paragraph
6, volume 1. My Lord, that's what
अटॉर्नी जनरल मंसूर उस्मान इस वक्त दलाइल दे रहे हैं।
maintainability for failing to meet the test criteria laid down under clause 3 of article 184, which is the matter must be of public importance, which is the matter must be of public importance first. Second, it must relate to enforcement of fundamental rights. My Lord, my first submission on whether these petitions raise or they raise any issue or question of public importance. My Lord, my learned friends, the counsel for the petitioners, they have largely, their case is rooted in lack of legislative competence, not necessarily objecting to the contents, all of them, but it's essentially rooted in lack of legislative competence of Parliament in terms of Article 191. And the argument, my Lord, is that because the powers and because this honorable court in 1980 had made rules, therefore the field stands occupied, and in any event, Parliament could not legislate. My Lord, firstly, insofar as public importance is concerned, my Lord would have now gone through the law, and my Lord would see that this law, in fact, deals with the concentration of powers, barring one provision, but concentration of powers in one office. What this law endeavors to do is, it democratizes this institution, brings more transparency, and structures the discretion, which is something, this structuring of discretion is something which has found favor with this court. The 7 principles enunciated in Amanullah case, PLD 1990, Supreme Court 1092.
PLD 1990,
Supreme Court 1092. Open policies, open plans, transparency, and so on, which this court has held that it is required of every, and of course it was with regards to the powers that the executive exercises. Now these are all administrative powers we are talking about. This law deals with largely, barring, of course, Section 3. There was a question that was raised. I'll address it towards the end, and Section 5, which I will address separately. So insofar as public importance is concerned, this law, in fact, deals with the issues which are important for public, which is the litigants. Secondly, insofar as independence of judiciary is concerned, my lords, there is no external element, which is to say that no other institution which has given any role whatsoever under this act insofar as practice and procedure of this court is concerned. It is all confined within this court. And that alone suffices insofar as the lack of any basis to challenge this act on the basis of violation of any fundamental right, because Article 9, yes, Article 9 as expounded by this court, access to justice and of course independence of judiciary is something which is which every citizen of this country is entitled to. So my respectful submission insofar as maintainability is concerned, these petitions fail on both counts. My lord, in continuum, as far as independence of judiciary is concerned, and I take your lordships to page 6 of this paper book. Starting from Government of India Act 1935, which was the first constitutional order of this country, under which Federal Court rules of 1950 were made. Under Section 214, subsection 1 of Government of India Act, the Federal Court could make rules, but with the prior approval of the Governor General at that time. And in 1950, the Governor General, of course, was neither part of Parliament, there was no constitution, but under the Government of India Act, Governor General wore several hats, and the executive authority vested in him, and of course part of some legislative authority as well. Under the 1956 Constitution, Article 177 read with 3rd Schedule, Part 1, Clause 3, the rules were made with the prior approval of the President. There was not even a mention of any law as far as the 1956 Constitution is concerned. 62. Under 1962 Constitution, Section 60, Article 65 said, subject to this Constitution and the law and with the prior approval of the President.
In 56 Constitution, the rule-making power was contained in 3rd Schedule.
Yes.
Had to be read with Article, I forget.
177.
That said,
subject to law And then
No, I didn't say subject to law. It said subject to Act of Parliament.
Act of Parliament, but I'll address that, which my lord has just pointed out.
वो ऐसी तो नहीं है
जी,
बात है.
I will address, my lord, that question.
ऐसी बात तो ना करें.
My lord, as far as, just bear with me.
आपने लिखा भी हुआ है यहाँ पे
Sir,
आर्टिकल
sir, एक second. I'll just Article 177. I'd read it out just for clarity. Until other provisions are made by an act of Parliament, third schedule would apply. And as far as 1956 Constitution is concerned, nothing happened under that Constitution, but the Constitution provision was until an act of Parliament is made with the prior approval of the President.
56 rules were made.
The 56 वाले
Rules were made under the 56 Constitution.
56 Constitution, and Act of Parliament was not made. 56 rules came with the prior approval of the President.
Is there any
So as far as
is there any difference between Act of Parliament and law?
I'll address that question, my lord. This is a question that I've noted, I'll address it. Under the 1962 Constitution, Article 65, subject to the Constitution and the laws, Supreme Court could make rules with the prior approval of the President. And same position, it was same position under the interim Constitution of 1972, which is Article 193.
I'm sorry, my apologies to interrupt, but the question here is surely when Governor General is referred to and the President is referred to, that's the executive branch. The 73 Constitution had the models from going back to 1935 up to 1972. It eschewed the controlling power of the executive branch. So surely the argument there is that the framers of the Constitution expressly were trying to strengthen the independence of the judiciary, and at least, if I may use the term, eliminating one particular branch from the equation. So the argument perhaps is the reverse of what you are saying.
No, I'm coming to that. I'm coming to that.
In mind.
No, I have it in mind. I have it in mind. And when I went through this, I noticed that the executive branch was removed, but not the legislative branch. So this is the effect of 1973. This is what has happened under Article 199. The executive action was.
It's a pointer in that of the direction in which constitutional law is traveling.
I'll address that. In India, my lords, under Article 145, Clause 1, it is subject to law and with the prior approval of the President, and so is the position in Bangladesh under Article 107, identical to what is in India and what we had.
In the Constitution, these references, when they say subject to approval of the President, is it unilateral discretion of the President, or it is President advised by the Chief Executive, albeit the Prime Minister, or whoever that is?
My lord, so if we look at the jurisdictions where we have this position, of course in India, he acts on the advice. And if, for example, under Article 191...
Government has the last say, not Parliament.
Yes. It was, no, my lord,
with the distinction. The prior approval of the President means effectively prior approval of the Prime Minister, not the legislature.
Yes.
Okay.
You said that in the Indian Constitution also it says subject to law, but that provision doesn't read like that. It's subject to the provisions of the law made by Parliament.
Yes.
So it's not subject to law.
I will come to that when I take you to Article 191. I'll come to that. I'll come to that when I take you to 191.
I'm just clarifying जो आपने argument की.
My lord.
वहाँ ये नहीं लिखा.
जी, when I'll address subject to law, I'll be addressing.
Page 7 page you reproduce.
Page 6 and 7, yes, ma'am. Now, in other jurisdictions, in United States, for example, this is 28 U.S. Code, Chapter 131, Section 2071. The rules made by the Supreme Court have to be consistent with the acts of Congress. And the latest development, or later development, is the Constitution Reform Act of 2005 of the United Kingdom. Now, under Section 45 of that act, the President of the US Supreme Court makes the rules, but is required to consult with the Lord Chancellor and all the bar councils while making the rules of procedure. So this is the progression, or this is this is how, this is the system that we have in place.
2000 UK Act, does that...
2005.
2005 UK Act, for example, do the rules have to be placed before the Houses of Parliament? Or is there any involvement at all by the legislative branch?
There is none, but...
He has to consult.
He has to consult. Now, whether...
Other than the Lord Chancellor, who is a dying breed sadly in the UK system, but anyway, it's not. Parliament has made the law despite their rule of sovereign legislative supremacy. The Parliament itself has said it's got to be totally independent of us.
Yes. And for that, now, I take your Lordship to Article 191. Now, this is where I will address what the term law means and what is the scope that this term has, and whether an Act of Parliament would be actually covered under the term law or not. Or whether we can give it a meaning where an Act of Parliament would be excluded from the definition of law and everything else would come under the...
Why? I don't even understand this debate. Why is this? What is the... I couldn't understand the point of counsel. What was he saying, really?
My Lord, the counsel was arguing, began by referring to Clause 1 of Article 8, where it said that any law or custom or using having force of law, etc., shall not be made. And then Clause 2 said that places a limitation, embargo on the state to not make any law which is inconsistent with the provisions of this, with the chapter.
This differentiation between an Act of Parliament and law, what is the significance here?
My Lord,
I missed the point. I tried to...
In my respectful submission, there would be none as far as Article 191
but
is concerned.
You were started by arguing on maintainability. Let's finish your argument. You're now addressing his arguments.
Gee, now what I'm on insofar as maintainability is concerned, my Lord, my submissions are that this law actually addresses the public concern. It addresses the issue of public importance by bringing in transparency and by structuring the discretion and by democratizing this institution, by and transparency, by conferring powers, or by, let's say, devolving powers.
Mr. Attorney General, so both sides agree that question of public importance is addressed in this. The only question is now whether a fundamental right has been violated,
yes.
And if a fundamental right has been violated, which fundamental right?
Correct.
Because question of public importance तो आप भी concede कर रहे हैं या कह रहे हैं कि है, इसमें आप उसको मुख्तलिफ तरीके से पॉइंट कर रहे हैं. आप कह रहे हैं जी पब्लिक इम्पोर्टेंस का क्वेश्चन है जिसमें हमने एड्रेस किया. The other side doesn't agree, but the common denominator is there is a question of public importance.
I think my lord is correct. To that extent, you are in agreement. Now, the other limb of the argument, I mean, public importance.
लेकिन ये जो ट्रकों के नीचे से
Other than that, I think
सुप्रीम कोर्ट के फुल कोर्ट बेंच में सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों की समाअत इस वक्त जारी है. दूसरी तरफ पीपल्स पार्टी के चेयरमैन बिलावल भुट्टो जरदारी मीडिया से गुफ्तगू कर रहे हैं. आइए देखते हैं.
हम इंपोर्ट्स करते थे, फूड सिक्योरिटी हमारा लॉ एंड ऑर्डर के लिहाज से दहशतगर्दी के, मगर उस सूरत हाल जब महंगाई था तो वो पाकिस्तान पीपल्स पार्टी थी जिसने बेनज़ीर इनकम सपोर्ट जैसे इनकलाबी प्रोग्राम शुरू किया, इस बात का एहसास करते हुए कि महंगाई है मगर हम इस मुल्क की गरीब तरीन औरतों को लावारिस नहीं छोड़ सकते. वो पाकिस्तान पीपल्स पार्टी की हुकूमत जिसने बहरान को ना सिर्फ समझा मगर फिर कहा इस बहरान से निकलने के लिए हमने पाकिस्तान की मरा हुआ ज़राए मीशत को ज़िंदा करना, और एक साल के अंदर ही अंदर, चाहे वो चीनी हो, चाहे वो गंदम हो, चाहे वो चावल हो, आप ना सिर्फ अपना ज़रूरियात पूरा कर रहे थे, but you went from being a food importer to an exporter. और आपका किसान का भी फायदा हो रहा था, मुल्क का मईशत का फायदा हो रहा था। वो कौन सा जमात है जो इस मुल्क के अवाम की नुमाइंदगी करते हैं, ना कि अशराफिया का नुमाइंदगी करते हैं? मैं समझता हूँ कि वो जमात पाकिस्तान पीपल्स पार्टी हमेशा वो स्पेस अपने पास रखती है, और आज भी अगर हमने इन मिसाइल
Clause 3, my lord.
पूरा पढ़ें
जी.
वन जो गवर्नमेंट वाला है ना,
Should I read 1 and 2 as well?
हाँ,
3 पढ़ दूं.
3 पढ़
3 पढ़ दूं. Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of importance with reference to the enforcement, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article.
In other words, which is the said article 199. So the High Court, you don't have to go for a public importance matter, you don't have to go for enforcement of fundamental rights, you can still go to the High Court. Here, we don't have extra powers, we have the same powers as the High Court, but we have two restrictions, public importance and enforcement of fundamental rights. Public importance is variable, let's stick to fundamental rights. So the power here is not a much larger power. My reading of the Constitution, a much narrower power than the High Court. High Court may strike down this law, arguably. And then we can sit in 184 as an appeal. Then we have more powers. I don't know, am I wrong in my understanding?
That's correct, my lord. And my lord, as far as challenge to the vires of this law.
Just to add to that, where a law deals with powers of this court, the Supreme Court of Pakistan, do you think it would be appropriate for the High Court to adjudicate upon it?
My lord, in another proceedings, this is a submission that I had made in other judgment where a specific question was raised, and my respectful submission at that time was that yes, and I maintain that position.
But are you aware there is a judgment of this court which says otherwise?
My lord, now I'm before a full court, so I'd just, based on that, I'd just proceed.
आगे बढ़ते हैं.
My lord.
I know you pressed for time.
Attorney General, can you explain the word enforcement? It's not the infringement of the fundamental right. It's the enforcement of the fundamental right. So,
public importance with reference to the enforcement. With reference to the enforcement.
Here, fundamental public importance, fine. Both parties are there. Now, had it been infringement, then you were right that there has to be a right which was infringed. Here, it's more wider. It's enforcement. So they are saying that this is a matter which relates to access to justice. So it's an enforcement of that particular right that they're talking about. They're not saying that it's an infringement of the fundamental right. Can you explain? Can you expound on that?
My lord. Now, of course, as I said, my lord, I reiterate that yes, access to justice is a right recognized by this court covered under Article 9, and to that extent, yes, it would be a fundamental right. Now, what they had to show was, the burden is up on them while challenging the constitutionality of this act on the basis of lack of enforcement of fundamental right, as my lord has just pointed out, not infringement of right. What they have to show is that this law does not, in fact, enforce this right of access to justice.
No. It's first we are at the threshold of the maintainability. We don't go into whether this law is right, whether it is wrong, whether it is enforcement of the fundamental right or it is an infringement. As far as maintainability is concerned, public importance is done. Then we come to this issue of, does the petition that they have filed, does the petition talk about enforcement of the fundamental right or not?
The petitioner, my lord, proceeds on the basis that by way of this act, powers conferred upon the Chief Justice under the Supreme Court rules have been curtailed or taken away, and that then results in this law being unconstitutional. It is not the case here that this act in any way prevents enforcement of any right.
Attorney General, one way of looking at it is the enforcement part, that whatever act has been challenged impedes the actualization of the fundamental rights. So perhaps it's interchangeably talking about infringement, but however uses a different word. So if a citizen comes and says this particular act thwarts or impairs the actualization of my fundamental right, I'm coming to the court. So enforcement or infringement might be synonymous. One more thing, I mean, I think the question of public importance also is a threshold entry point. Suppose if we see, don't you think the petitioner will have to show that in order for it to be a question of public importance, there must be apparently that law must be against public interest. But suppose if it's clearly in favor of public interest, does it constitute a question of public interest? To become a question of public interest, it must apparently prima facie be something against public interest, and then you say, yes, it's a question. But if it's so obvious that the whole law is in public interest, for example, do you think there's a threshold to that effect, or there isn't any?
My first part of my submission, my lord, was that the question of public importance, my lord, when I pointed out that what this law does is it democratizes this institution, brings more transparency, structures the discretion, it actually advances that public interest. And therefore, they fail on that threshold, that count as well.
Attorney General,
my lord.
On my repeated questions, in response to my repeated questions, they conceded very explicitly that this is a good law. It enhances access to justice, and also, speaking for myself, it addresses a very, very big issue of internal and institutional independence. Now, in that context, when this is an admitted fact, the only question whether the parliament had the competence or not, क्या जो 184(3) की requirements है, वो fulfill होती है? Because there is no enforcement of fundamental rights.
My lord, if that is so, then these petitions have to be rejected on this basis alone, because insofar as legislative competence is concerned, 184(3) cannot be pressed into service.
So
if we'll let you, I think a lot of questions are coming up. We'll note. I'll try to make a point.
These are, my lord. Please.
Well, अगर आप थोड़ा सा अपना continue रखें, I want to know where you're going. Okay.
Attorney General, if I may ask you a question, is it in the public interest that Parliament, or for that matter, a provincial assembly, remains within the limitations that may be placed by the Constitution on Parliament or a provincial assembly? Is it in the public interest?
My lord, which fundamental right would it
I'm not
be
talking
affected?
of fundamental right. I'm talking of public interest.
Of course.
Of course.
Yes.
So therefore, if a law...
Again, this is happening, which I must, interject. I would, you have agreed with now here, I won't agree with you. I will say it may be unconstitutional, but not within the parameters of 184(3). There may be a lot of unconstitutional things going on in Pakistan, but it won't come within the parameters of 184(3). That is the fundamental point. That's my way of approaching it. Others have different ways of approaching it. So I think आप जरा चलिए फिर आप नोट कर लें सवाल.
I just this part I just
conclude. If I may continue, sorry, if I may continue. It is in the public interest. I'm not speaking of any fundamental right. I'm only speaking of public interest. It is in the public interest you accept, and I think rightly so, that because we have a federal structure, Parliament and provincial assemblies must remain within constitutional limits, right? Whatever those constitutional limits are. So therefore, it seems to me to follow logically that if Parliament makes a law that is ultra vires, or a provincial assembly makes a law that is ultra vires, it is in the public interest to challenge that law. Because if remaining within the constitutional limits is in the public interest, then going beyond those limits and making an ultra vires law is surely a breach of public interest. What would you say to that?
That touches upon the legislative competence.
No, I'm talking of public interest.
Yes, but any law, a law cannot be struck down on the basis of just being public.
Where the challenge can be is a separate.
My lord, let's just take a step back. Any law made by any legislature, provincial assemblies or the parliament, would be a matter of public interest and importance. It is a law which is being enacted. Now, in order to examine that law, in order to assume jurisdiction to examine that law, we have to look at, in the case of Supreme Court, Article 184, and the cases of High Court in 199.
नहीं, आप
Now,
देखिए, आप तो कह रहे हैं ना, मैंने जो नोट किया, हो सकता है मैंने फिर गलत नोट किया हो, आप तो कह रहे हैं कि this challenge fails on both counts.
Yes.
Public interest and this.
जी.
तो मैं अभी सिर्फ public interest पे देख रहा हूँ ना.
But
तो मैं आपसे पूछ रहा हूँ, I mean, speaking for myself, it seems to me that any law which is ultra vires, whether by parliament, whether by provincial assembly, meaning breaches the limitations, whatever they may be, imposed by the constitution, because the constitution is supreme. It is contrary to public interest. Has to be.
now let me just quickly address this, because this is a maintainability issue here, and I want to address that issue here first and foremost. The two conditions provided under Clause 3 or required under Clause 3 are connected. It has to be a matter of public importance with reference to enforcement of fundamental rights. Now, independently, any legislation, any statute, any rule or any regulation would be a matter of public importance or public interest for that matter. Now, in order for this court to assume jurisdiction, now this court does not assume jurisdiction under 184(3) on a legislature, on any law being enacted for want of legislative competence. It has to be ultra vires or violative of the rights, fundamental rights granted.
So you say that the word relating to enforcement.
With reference to the enforcement of.
That you say is the buckle that connects the two things.
That is the buckle that connects the two, and that is where it actually prevents, if I may say so, this court to examine constitutionality of a statute on legislative competence.
Is legislative competence not in the public interest?
As I said, Your Ladyship, this is something, legislative competence alone is something which can only be examined under 190.
Is it not a right that everyone has under the Constitution
My Lord,
that laws are made in a particular way?
Legislative competence, of course, as I understand it, what you have to see in the act of, when is an act of parliament, whether Article 70 read with the list permitted it or not, or whether there is a provision of the constitution which directly confers that power upon the parliament, whether that provision permits it or not. And if those provisions do not permit that legislature to legislate on that particular matter, then yes, this is a legislative competence issue and it is not permissible under 184(3)
So
to touch.
in your opinion, the law is good law, parliament is competent to make the law, and every provision of the law is valid and does not in any way violate any provision of the Constitution. So then what happens again? I go back to the full court hearing aid, and you are given a right of appeal under that. So are they not then entitled to their right of appeal in the event that the court decides that these petitions are not maintainable? They cannot challenge it? And does that not go to the fact that once again you've put the burden on the court itself to decide when it wants to constitute a full court and block that right of appeal, and when it wants to constitute a smaller bench and allow that right of appeal?
And whether the act is in field or is it suspended?
I think my illustrious colleague has raised a very valid point, and I was thinking about it during the break. And if we read the right of appeal, first of all it talks about an aggrieved person. Now I'm trying to envisage a scenario where one would be aggrieved. First scenario. Second thing is, we can, and this is permissible, read down legislation. We can, for instance, read into it that wherever there is a full court, needless to say, you cannot have a right of appeal over the full court, so that one can read down the legislation that those cases. But which right have we determined? What have we taken away from someone? Someone gets an extra right to challenge a judgment, if at all it's an irritation to us. Oh, now you have to have the appeal. Oh, now the review jurisdiction has been extended. So, what are we doing? And it's not conferring this power to an executive functionary, to the legislature, to the president, or to anybody else. It may be nuisance value for us. Our reviews are going, our appeals are going, that sort of thing. What are we taking away? If the judgment is correct and in order, should we shy away from looking at it because someone files an appeal? Yes, it may bring in litigation into the court. That's the downside, may be said. But where is the aggrieved person? Who will be the aggrieved person be? The person affected. Because I think the 184.3, the whole intendment of that was for not for lawyers. It was not for the well-to-do. It was not for the multinationals. It was for the poor, the dejected of society. We have a whole chapter on the principles of policy, which no one bothers to, we don't read. Bonded laborers, transgender, women rights, children, they can't come to court. We can intervene, 184.3 can come to their rescue. So I was looking at things in that perspective. We have to see the whole entire constitution as a whole. We just stuck with one provision that somebody says, hey, please tell me how you aggrieved. I kept asking him, are you aggrieved? He says, no. They couldn't do it, you can do it. That's about the argument that I've understood so far. That's a valid argument on its own. Yes, to be addressed, for instance, the income tax ordinance has certain provisions that have been challenged before the High Court. Could we entertain it at 184.3? After all, it is legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But it is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route, get a 191 petition, come to the Supreme Court in 184. That is the appellate jurisdiction. So we should read the Constitution and not just pick the words. We are just stuck with these words, 2 words also. Who's harmed by this? The only thing is you've taken away our power, you've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another same lawyer. Okay, person wants to waste money on another lawyer, do so. So his pocket will be lighter. What is it to us?
आगे बढ़े थोड़ा सा. If I may, sorry, here, take you back to what you were saying about, and I understand your point, relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court, and that is, you say, you accept that any law which is ultra vires is against the public interest, but you say the buckle is missing, because it doesn't, it's not just legislative competence alone, but it has to relate to fundamental rights. So I was just wondering.
If I may rephrase it before my Lord formulates the question. Legislative competence cannot be interfered with here.
No, I'm just saying, I understand that.
Yes.
So he may care on.
Yes.
But breach of legislative competence is contrary to the public interest. Until it is related to fundamental right, 184.3 cannot be invoked. This is your argument. So I was just wondering that the subject matter of this law essentially is the practice and procedure of the Supreme Court. Article 10A relates to due process. So surely any law relating to the practice and procedure of any court, but let's take the Supreme Court, which is ultra vires, surely that affects due process and therefore is directly relatable to a fundamental right. What would you say to that?
And that is where, when passing this threshold, of course, when a petition comes before your lordships or before this court under 184.3, these are the 2 things which are to be examined at first instance. Now, once this threshold is met, then, and the burden is just discharged.
You Article 10A. It helps sometimes to refresh our memories.
For the determination of his civil rights.
Of his civil right, not the Supreme Court civil rights. आगे पढ़ें.
And obligations, or in any criminal charge against him, a person shall be entitled to a fair trial and due process.
It's nothing to do with the Supreme Court's due process. It's his. Have your right of appeal been taken away? Your right of cross-examination been taken away? Have your right of a statement under 340 been taken away?
So that's where then it takes me, my
Surely,
lord,
Mr.
and I
Attorney-
just
Mr.
addressing your
Mr.
question.
Attorney General, the subject matter is legislative competence in relation to practice and procedure. Surely as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because it is ultra vires, it can't be due process.
So let's proceeding on this. Proceeding on this.
Whatever it says, whether it says
I'll go with it.
Chief Justice is masters of the roster or five.
I'll go with it, and let me just make my submission on this. I'll go with it. When somebody brings in, and let's assume, for the sake of argument, let's assume, and for a moment, if it is assumed that yes, it is a matter with reference to fundamental rights as well, then what has to be shown in the first instance is that this legislation fails to enforce or infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
they have not shown anything to say that there is any due process which they are entitled to under the existing scheme or the scheme as it stood prior to this act.
We made questions. You can continue. I think we have our own views and opinions. आप चलें आगे.
Now
you have to persuade us, not we have to persuade you.
Just one question. I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been dismissed under Article 185, another appeal would be available to the litigant before a larger bench. Would that law stand?
I would rather consider these.
Competence ki baat
let's consider what this law did. Maybe tomorrow that very matter comes before us.
So the question is.
A second appeal. My Lord's question is whether the second appeal would be provided.
Not at all. I am questioning the competence. The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, can be provided by ordinary legislation? The example I gave you was an extreme example. The first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the Supreme Court?
I will add to this question. Is there any provision in the Constitution preventing
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो enlarge किया, पहले एक अपील थी अब हमने दूसरी कर दी है, तो इसलिए ये हमारी competence में है. Would that argument stand?
Noted, my lord.
आप बाद में जवाब दे दें, आगे बढ़ते हैं.
ऐड कर रहा हूँ उसमें दूसरी तरीके से. Is there any provision in the Constitution preventing the Parliament from doing so?
It's noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General, please you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically. And Article 4, Article 25.
My lord.
And subsequently in section 3, specifically talks about 184.3.
My lord.
How this can be
proceeded
under Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord.
How that can be moved before the Supreme High Court under Article 199 of the Constitution?
My lord, I noted. My lord, now the question that has come before your lordship is whether this Act, 2023 Act, is covered under the definition of law, howsoever expansive definition, howsoever expansively the term law is defined. My lord, Article 260 has two definitions. One is of an Act of Parliament and the other is of a federal law. Here we are dealing with a federal law. Article 260 defines a federal law. It says,
You say over here, law includes statute law.
yes,
So, point.
yes. In my respectful submission, law can only have one meaning as far as this provision is concerned. But even if it is given an expansive meaning, this act would surely be covered under the definition of
And
law.
if it's to be covered, then why didn't the Constitution say by an act of Parliament? Why did it use the word law? These words are not interchangeable. They are used in a very specific sense in different articles. And so you have to, the interpretation has to be given to the word law and not to just say, just because law includes legislation, so here it will be legislation alone. Law has a meaning, and if the Constitution wanted to say just by an act of Parliament, it would have used those words.
Your Ladyship, when we look at the provisions from where the Parliament draws its
Why did you
legislative
look at 75(3)?
जी 75(3) and 141 and 142 as well.
पढ़ लेते हैं जरा, उसमें दोनों लफ्ज इस्तेमाल हो गए.
When the President has assented or is deemed to have assented to a bill, it shall become law and be called an act of Majlis-e-Shura. So
Law
it
is
is
what happens. What it is, the name of the thing is, you are a man. Your name is Mansoor Rahman. I would read it like that.
And the definition of federal law under Article 260 is, federal law means a law made by or under the authority of Majlis-e-Shura Parliament. Now, if we turn to Article 8(2), for the sake of this submission, where any law which is in
समाअत का सिलसिला जारी है और अटॉर्नी जनरल मंसूर उस्मान इस वक्त अपने दलाइल दे रहे हैं.
यहाँ लेंगे एक ब्रेक, हमारे साथ रहिए.
Breathe out now, open your eyes.
इस शर्मिंदा कर देने वाली खारिश की